Small world, the world of informative flashcards. Flashcards in mediation law. Alternative dispute resolution, Part 2. Meaning of appointing authority. Section 26, Meaning of appointing authority. Appointing authority as used in the model law shall mean the person or institution named in the arbitration agreement as the appointing authority, or the regular arbitration institution under whose rules the arbitration is agreed to be conducted. Where the parties have agreed to submit their dispute to institutional arbitration rules, and unless they have agreed to a different procedure, they shall be deemed to have agreed to procedure under such arbitration rules for the selection and appointment of arbitrators. In ad hoc arbitration, the default appointment of an arbitrator shall be made by the National President of the Integrated Bar of the Philippines, IBP, or his duly authorized representative. What functions may be performed by appointing authority? Section 27. What functions may be performed by appointing authority? The functions referred to in Articles 11, 3, 11, 4, 13, 3, and 14, 1, of the model law shall be performed by the appointing authority, unless the latter shall fail or refuse to act within 30 days from receipt of the request, in which case the applicant may renew the application with the court. Grant of interim measure of protection. Section 28. Grant of interim measure of protection. A. It is not incompatible with an arbitration agreement for a party to request, before constitution of the tribunal, from a court an interim measure of protection and for the court to grant such measure. After constitution of the arbitral tribunal and during arbitral proceedings, a request for an interim measure of protection or modification thereof may be made with the arbitral tribunal, or to the extent that the arbitral tribunal has no power to act or is unable to act effectively, the request may be made with the court. The arbitral tribunal is deemed constituted when the sole arbitrator or the third arbitrator who has been nominated has accepted the nomination and written communication of said nomination and acceptance has been received by the party making request. B. The following rules on interim or provisional relief shall be observed. 1. Any party may request that provision relief be granted against the adverse party. 2. Such relief may be granted to prevent irreparable loss or injury, to provide security for the performance of any obligation, to produce or preserve any evidence, or to compel any other appropriate act or omission. 3. The order granting provisional relief may be conditioned upon the provision of security or any act or omission specified in the order. 4. Interim or provisional relief is requested by written application transmitted by reasonable means to the court or arbitral tribunal as the case may be and the party against whom the relief is sought, describing in appropriate detail the precise relief, the party against whom the relief is requested, the grounds for the relief, and evidence supporting the request. 5. The order shall be binding upon the parties. 6. Either party may apply with the court for assistance in implementing or enforcing an interim measure ordered by an arbitral tribunal. 7. A party who does not comply with the order shall be liable for all damages resulting from noncompliance, including all expenses and reasonable attorney's fees paid in obtaining the order's judicial enforcement. Further authority for arbitrator to grant interim measure of protection. Section 29. Further authority for arbitrator to grant interim measure of protection. Unless otherwise agreed by the parties, the arbitral tribunal may, at the request of a party, order any party to take such interim measures of protection as the arbitral tribunal may consider necessary in respect of the subject matter of the dispute following the rules in Section 28, paragraph 2. Such interim measures may include but shall not be limited to preliminary injunction directed against a party, appointment of receivers or detention, preservation, inspection of property that is the subject of the dispute in arbitration. Either party may apply with the court for assistance in implementing or enforcing an interim measure ordered by an arbitral tribunal. Venue or place of arbitration. Section 30. Place of arbitration. The parties are free to agree on the place of arbitration. Failing such agreement, the place of arbitration shall be in Metro Manila, unless the arbitral tribunal, having regard to the circumstances of the case, including the convenience of the parties, shall decide on a different place of arbitration. The arbitral tribunal may, unless otherwise agreed by the parties, meet at any place it considers appropriate for consultation among its members, for hearing witnesses, experts, or the parties, or for inspection of goods, other property, or documents. Provision regarding the language of the arbitration. Section 31. Language of the arbitration. The parties are free to agree on the language or languages to be used in the arbitral proceedings. Failing such agreement, the language to be used shall be English in international arbitration, and English or Filipino for domestic arbitration, unless the arbitral tribunal shall determine a different or another language or languages to be used in the proceedings. This agreement or determination, unless otherwise specified therein, shall apply to any written statement by a party, any hearing and any award, decision or other communication by the arbitral tribunal. The arbitral tribunal may order that any documentary evidence shall be accompanied by a translation into the language or languages agreed upon by the parties or determined in accordance with paragraph 1 of this section. Law governing domestic arbitration. Chapter 5. Domestic arbitration. Section 32. Law governing domestic arbitration. Domestic arbitration shall continue to be governed by Republic Act No. 876, otherwise known as the Arbitration Law as amended by this chapter. The term domestic arbitration as used herein shall mean an arbitration that is not international as defined in Article 3 of the Model Law. Applicability to domestic arbitration. Section 33. Applicability to domestic arbitration. Article 8, 10, 11, 12, 13, 14, 18 and 19 and 29 to 32 of the Model Law and Section 22 to 31 of the preceding Chapter 4 shall apply to domestic arbitration. Arbitration of construction disputes, governing law. Section 34. Arbitration of construction disputes, governing law. The arbitration of construction disputes shall be governed by Executive Order No. 1008, otherwise known as the Constitution Industry Arbitration Law. Coverage of the law. Section 35. Coverage of the law, construction disputes which fall within the original and exclusive jurisdiction of the Construction Industry Arbitration Commission. The Commission shall include those between or among parties to, or who are otherwise bound by, an arbitration agreement, directly or by reference, whether such parties are project owner, contractor, subcontractor, quantity surveyor, bondsman, or issuer of an insurance policy in a construction project. The Commission shall continue to exercise original and exclusive jurisdiction over construction disputes, although the arbitration is commercial, pursuant to Section 21 of this Act. Authority to act as mediator or arbitrator. Section 36. Authority to act as mediator or arbitrator. By written agreement of the parties to a dispute, an arbitrator may act as mediator and a mediator may act as arbitrator. The parties may also agree in writing that, following a successful mediation, the mediator shall issue the settlement agreement in the form of an arbitral award. Appointment of foreign arbitrator. Section 37. Appointment of foreign arbitrator. The Construction Industry Arbitration Commission, or CIAC, shall promulgate rules to allow for the appointment of a foreign arbitrator or co-arbitrator or chairman of a tribunal, a person who has not been previously accredited by CIAC, provided that a. The dispute is a construction dispute in which one party is an international party. b. The person to be appointed agreed to abide by the arbitration rules and policies of CIAC. c. He/she is either co-arbitrator upon the nomination of the international party, or he/she is the common choice of the two CIAC-accredited arbitrators first appointed, one of whom was nominated by the international party, and d. The foreign arbitrator shall be of different nationality from the international party. Applicability of this law to construction arbitration. Section 38. Applicability to construction arbitration. The provisions of Section 17 of Chapter 2 and Section 28 and 29 of this Act shall apply to arbitration of construction disputes covered by this chapter. Procedure to follow for cases involving a construction dispute. Section 39. Court to dismiss case involving a construction dispute. A regional trial court which a construction dispute is filed shall, upon becoming aware, not later than the pretrial conference, that the parties had entered into an arbitration to be conducted by the CIAC, unless both parties, assisted by their respective counsel, shall submit to the regional trial court a written agreement exclusive for the court, rather than the CIAC, to resolve the dispute. Confirmation of award. Chapter 7. Judicial Review of Arbitral Awards. A. Domestic Awards. Section 40. Confirmation of award. The confirmation of a domestic arbitral award shall be governed by Section 23 of RA 876. A domestic arbitral award, when confirmed, shall be enforced in the same manner as final and executory decisions of the regional trial court. The confirmation of a domestic award shall be made by the regional trial court in accordance with the rules of procedure to be promulgated by the Supreme Court. A CIAC arbitral award need not be confirmed by the regional trial court to be executory as provided under EO No. 1008. Vacation Award. Section 41. Vacation award. A party to a domestic arbitration may question the arbitral award with the appropriate regional trial court in accordance with the rules of procedure to be promulgated by the Supreme Court only on those grounds enumerated in Section 25 of Republic Act No. 876. Any other ground raised against a domestic arbitral award shall be disregarded by the regional trial court. What governs of foreign arbitral awards? B. Foreign arbitral awards. Section 42. Application of the New York Convention. The New York Convention shall govern the recognition and enforcement of arbitral awards covered by the said convention. The recognition and enforcement of such arbitral awards shall be filled with regional trial court in accordance with the rules of procedure to be promulgated by the Supreme Court. Said procedural rules shall provide that the party relying on the award or applying for its enforcement shall file with the court the original or authenticated copy of the award and the arbitration agreement. If the award or agreement is not made in any of the official languages, the party shall supply a duly certified translation thereof into any of such languages. The applicant shall establish that the country in which foreign arbitration award was made is a party to the New York Convention. If the application for rejection or suspension of enforcement of an award has been made, the regional trial court may, if it considers it proper, vacate its decision and may also, on the application of the party claiming recognition or enforcement of the award, order the party to provide appropriate security. Recognition and enforcement of foreign arbitral awards not covered by the New York Convention. Section 43. Recognition and enforcement of foreign arbitral awards not covered by the New York Convention. The recognition and enforcement of foreign arbitral awards not covered by the New York Convention shall be done in accordance with procedural rules to be promulgated by the Supreme Court. The court may, grounds of comity and reciprocity, recognize and enforce a non-convention award as a convention award. What is the effect if a foreign arbitral award is confirmed by our regional trial court? Section 44. A foreign arbitral award, when confirmed by a court of a foreign country, shall be recognized and enforced as a foreign arbitral award and not a judgment of a foreign court. A foreign arbitral award, when confirmed by the regional trial court, shall be enforced as a foreign arbitral award and not as a judgment of a foreign court. A foreign arbitral award, when confirmed by the regional trial court, shall be enforced in the same manner as final and executory decisions of courts of law of the Philippines. May a party reject a foreign arbitral award? If yes, on what ground? Section 45. Rejection of a foreign arbitral award. A party to a foreign arbitration proceeding may oppose an application for recognition and enforcement of the arbitral award in accordance with the procedural rules to be promulgated by the Supreme Court only on those grounds enumerated under Article 5 of the New York Convention. Any other ground raised shall be disregarded by the regional trial court. Where to appeal from RTC'S decisions on arbitral awards? Section 46. Appeal from court decisions on arbitral awards. A decision of the regional trial court confirming, vacating, setting aside, modifying or correcting an arbitral award may be appealed to the Court of Appeals in accordance with the rules of procedure to be promulgated by the Supreme Court. The losing party who appeals from the judgment of the court confirming an arbitral award shall require by the appellant court to post counterbond executed in favor of the prevailing party equal to the amount of the award in accordance with the rules to be promulgated by the Supreme Court. What is the venue and jurisdiction for recognition and enforcement of an arbitration agreement? Section 47, Venue and Jurisdiction. Proceedings for recognition and enforcement of an arbitration agreement or for vacation, setting aside, correction or modification of an arbitral award, and any application with a court for arbitration assistance and supervision shall be deemed as special proceedings, and shall be filled with the regional trial court. Where arbitration proceedings are conducted. Where the asset to be attached or levied upon, or the act to be enjoined is located. Where any of the parties to the dispute resides, or has his place of business, or in the National Judicial Capital Region, at the option of the applicant. Procedure for the sending of notice. Section 48, Notice of proceeding to parties. In a special proceeding for recognition and enforcement of an arbitral award, the court shall send notice to the parties at their address of record in the arbitration, or if any party cannot be served notice at such address, at such party's last known address. The notice shall be sent at least 15 days before the date set for the initial hearing of the application. What office tasked to head or be the Secretariat? Section 49, Office for Alternative Dispute Resolution. There is hereby established the Office for Alternative Dispute Resolution as an attached agency to the Department of Justice, or DOJ, which shall have to be headed by an executive director. The executive director shall be appointed by the President of the Philippines. The objective of the office are: A. To promote, develop and expand the use of ADR in the private and public sectors, and B. To assist the government to monitor, study and evaluate the use by the public and the private sector of ADR, and recommend to Congress needful statutory changes to develop. C. Strengthen and improve ADR practices in accordance with world standards. What are the powers and functions of the Office for Alternative Dispute Resolution? Section 50. Powers and functions of the Office for Alternative Dispute Resolution. The Office for Alternative Dispute Resolution shall have the following powers and functions. A. To formulate standards for the training of the ADR practitioners and service providers. B. To certify that such ADR practitioners and ADR service providers have undergone the professional training provided by the Office. C. To coordinate the development, implementation, monitoring, and evaluation of government ADR programs. D. To charge fees for their services, and E. To perform such acts as may be necessary to carry into effect the provisions of this Act. Any appropriations by the government for the implementation of this law? Section 51, Appropriations. The amount necessary to carry out the provisions of this Act shall be included in the General Appropriations Act of the year following its enactment into law and thereafter. Who is tasked to draft the implementing rules and regulations, IRR, of this law on mediation? Section 52, Implementing Rules and Regulations, IRR. Within 1 month after the approval of this Act, the Secretary of Justice shall convene a committee that shall formulate the appropriate rules and regulations necessary for the implementation of this Act. The committee, composed of representatives from A. The Department of Justice, B. The Department of Trade and Industry, C. The Department of the Interior and Local Government, D. The President of the Integrated Bar of the Philippines, E. A representative from the arbitration profession, and F. A representative from the mediation profession, and G. A representative from the ADR organizations, shall within 3 months after convening, submit the IRR to the Joint Congressional Oversight Committee for review and approval. The Oversight Committee shall be composed of the Chairman of the Senate Committee on Justice and Human Rights, Chairman of the House Committee on Justice, and 1 member each from the majority and minority of both houses. The Joint Oversight Committee shall become functus officio upon approval of the IRR. What is the applicability of the Katarungan-Pambarangay Law? Section 53. Applicability of the Katarungan-Pambarangay. This Act shall not be interpreted to repeal, amend or modify the jurisdiction of the Katarungan-Pambarangay under Republic Act No. 7160, otherwise known as the Local Government Code of 1991.